ever had a higher percentage of Senate confirmed officials in the audience than we do at this moment. And I also have to say, when you have Bob McKenzie in the audience, the level of engagement and enthusiasm just with him alone is really high. So for any of the speakers who are needing that love and engagement, just look at Bob. He really is an exceptional part of our community, and with Blake Reed here, the Twitter feed will still be on fire, even with fewer people, and he's got more pressure on him now to keep it going. Speaking of Twitter feeds, I don't know if Barron's here yet, but Barron did make a request. Jolie will work with Ariel. Amazing, their dynamic duo. If you have a car and you're going to the airport and you can take people, let them know, right? Ariel right here, everyone knows Ariel at this point. If you need a lift to the airports, let them know, and they'll help facilitate that. Given the intimate conversations we'll have this morning, we'll all get to know each other anyway. The second panel is going to reflect that intimacy. I will be stepping in to present not one, but two of the presenters who are not able to be here, and we'll look forward to having more time for engagement discussion around intellectual property. And now I turn it over to our dynamic duo, Jolie.
Thank you all. Good morning. As was mentioned yesterday and last night, I'm the current editor-in-chief of our Colorado Technology Law Journal. And so to start the day, I'd just like to make a few announcements about the journal and say thanks to all of you in the audience that have supported the journal for many years. First of all, we continue to be excited about the journal's website, and you can check out the new and improved website at ctlj.colorado.edu. We have our latest issue from last year up there that was published at the end of 2015. It's also available to pick up outside at the registration table. So if you're interested in picking up a copy for reading on your way to the airport or at the airport, I think that's a good thing to do. I'm also excited that the journal will host its first ever alumni event this spring, and that's a nice thing for us to continue the legacy of the journal. I'm sure that while you've been here over the last day and hopefully today, you'll get to know sort of the spirit of this place, which is reflected in the journal. And I think that that's a collaborative effort of friendship and teamwork. And so we're excited to have an event to grow and continue that legacy. I'm also very excited to announce, and I think most of you have heard now, that our symposium editor for this year, Ariel Diamond, will be the next editor-in-chief of our journal. And I'm very excited to see what she and her team will accomplish next year. I know that they will do a great job. So thank you all for your support and for being here today. And I'd like to turn it over to Ariel.
Good morning. Thank you, Jolie and Dean Weiser. So my name is Ariel Diamond. I am the symposium editor for this conference, and I'll be next year's editor-in-chief. I'm so excited to take over this position, and I follow in the footsteps of amazing leaders from the journal before me, and it makes me very comfortable taking over this position, which can seem daunting, but I know that we have the leadership in place and the mentors and all of you here at this conference to help us along the way, and we really appreciate that more than along with our great faculty. So I think a lot of you here this weekend have got to meet our board for next year. A lot of our members who will be taking over editorial positions next year were volunteering at the front tables and giving rides. So we hope to continue building relationships with you next year, and you can get to know our executive board and our incoming members a little better. So thank you all for your support, and we're very excited for next year. It is my pleasure to introduce Professor Paul Ohm this morning for his chat with Chairwoman Ramirez. Professor Ohm is a professor of law at the Georgetown University Law Center. He specializes in information privacy, computer crime law, intellectual property, and criminal procedure. Professor Ohm began his academic career on the faculty here at the University of Colorado, where he also served as Associate Dean for Academic Affairs and the Faculty Director for the Silicon Flatiron Center. From 2012 to 2013, Professor Ohm served as Senior Policy Advisor to the Federal Trade Commission. and we are very excited to have him here with us today. And best yet, it looks like everyone's going to get their wish of not having Paul leave the state.
Yeah, I mean, it's been said many times, but you Colorado people don't know how to deal with snow. Take it from a DC native, we know snow. It's really my distinct pleasure to be back. It's great to see so many recent students and alums, and it's my distinct pleasure for the third year in a row now to be up here with Chairwoman Edith Ramirez. The longer biography is in the program, but I can't resist some highlights. She has served as the chairwoman of this agency since March of 2013 and a commissioner since 2010. She was renominated to both of those posts just this past December. Prior to this, she was not ever shoveling snow in Los Angeles as a litigation partner, focusing a lot on patent litigation and other forms of litigation. She has been a tireless and extremely effective steward of this agency. They have done lots of enforcements in competition, consumer protection, and the topic that's nearest and dearest to my heart, information privacy, where they are rightfully seen as the kind of national focus of a government agency attention, with a lot of help from other agencies when it comes to nuanced thinking about information privacy. And I will notice, just one more thing I'll note is in October she received the National Consumers League's highest award, the Trumpeter Award, so congratulations on that. A testament to the way that this agency continues to leave a mark under her leadership on privacy issues and other consumer protection issues. The format, which by now is a Silicon Flatirons standby, is we're going to have a conversation up here for the majority of the 45 minutes we're together. But at the end, I will reserve time for a couple of questions from the audience. Okay, so let's just kick it off. Recently, I think it was only a few weeks ago, the FTC put out its big data report. One thing I've always said about the Federal Trade Commission is they have an uncanny knack for seeing the next big issue around the corner. And that's true for big data as well, which the agency and you in particular were talking about 3 or 4 years ago before it became one of the buzz phrases. That means nothing, but also is talked about all the time in Washington, D.C. And among the many, many interesting insights and conclusions in the report, I'm going to read one line, which is, certain uses of big data analytics may harm consumers, particularly low-income and underserved populations. I read this, and I thought it was really an intriguing line. It was really a big challenge of big data, and I thought it also dovetailed with what I've seen the FTC do with underserved populations generally. I did notice on your website that the FTC now publishes telenovelas or comic books targeted at the Spanish-speaking individuals. The agency focuses on fraud committed on the elderly. So can you say a little bit more about what you learned in that process about this particular part of the big data problem or big data challenge?
Sure. And let me just start off by thanking Phil for inviting me to participate in this conference. It's really just a tremendous honor for me to be here. And it's always a delight, Paul, to be doing this, having this conversation with you. So let me place our big data report in a slightly broader context, and you alluded to it by referencing this other work that we've been doing vis-a-vis our focus on ensuring that consumer protection, that we're handling our mandate with regards to consumer protection in the most effective way possible. We spend a lot of time at the Federal Trade Commission trying to understand how the marketplace is working, and so we spend a lot of time understanding new business models, the way that technology impacts consumers' lives. So a lot of time clearly is devoted to that part of what we do, but we also need to pay attention to the other dynamic, which is the consumers themselves. And I think that one of the challenges, but is also an opportunity for the agency, is to deal with the changing demographics of the U.S. population. And that includes the fact that our population is getting older. Of course, it's increasingly diverse. So we need to be, in order to be effective as an agency, we need to be aware of the way that different communities are interfacing and interacting with the marketplace. And if we're not paying attention to that issue, then no matter how well we may know or be familiar with the the way the markets are operating, we're not going to be effective as an agency. So that's something that I think the FTC has been doing dating back to Chairman Ramirez, who placed a focus on how fraud was impacting the Latino community in particular. And I've placed a even bigger emphasis on that, making sure that the work that we do takes into account impacts on the elderly, on military families, on low income. So I think that this is part of that broader effort. I would say that it also links to our other work in another way, which is that we're also very conscious of the way that the collection of information and the fact that our economy now depends so much on data, and data is becoming a currency, and more is known, companies know more and more about us. How does that also tie into the bread and butter of our fraud work as well? And so we've been keeping an eye on linkages between the fraud work that we undertake and also how that might be impacted by the fact that there is so much information that is being collected, compiled, sold. And so in some of our fraud work, you will see how that is something that we're keeping an eye on. We've brought some enforcement actions where against a couple of data brokers, for instance, that have purchased payday loan applications and then sold that information, and it's ended up being used by fraudsters. So that's another link. More specifically then, turning to the big data report itself, it really was an outgrowth, this project was an outgrowth of our work and our report on data brokers, on the data broker industry. Shortly after we issued that report in 2014, we held a workshop to address how big data might be used in a positive way to expand opportunities and to include parts of our population that may find themselves on the margins economically, and also what kind of impact that might have on racial minorities. And the data broker report really focused on the early parts of I'll call it the life cycle of data. So we focused on the collection of data. We explained how data brokers aggregate offline, online information, compile it, create profiles of pretty much nearly every single US consumer, and then they package it and sell that information. The big data report then examined how that information can be used. And one thing that we learned when we looked at the data broker industry is that in addition to compiling these profiles, consumers are being placed into certain categories. Right. And sometimes those categories, there'll be designations that where low income might be placed in a particular category. Certain minorities might be placed in another category. And so we wanted to explore, okay, well, what is the impact of that, and how is that information being used?
Yeah, and I mean, I think if I'm remembering correctly, I'm not going to remember all the labels they gave to those categories, but I think one was called urban strivers, and when you unpack that, it really is both a class and a race designation effectively. And one thing you address in the paper, and I think is one of the big challenges of this whole question, is the difference between intentional discrimination and something you can blame a machine for, right? And I think increasingly the people who run big machine learning algorithms are going to say, we agree that's a regrettable result. We'll try not to do that in the future. But you can't enforce against us, or you can't even chide us publicly because it was the machine doing the talking, not us.
That's exactly right. I think what we're trying to the point that we're trying to make with this report is we're trying to heighten awareness. There's a tendency to think that just because you're collecting and that the volume of information that you have it's much larger, that somehow that will mean that your results are going to be more accurate. And of course, we know that that's not necessarily the case. Right. So what we're examining, without losing sight of course, all of the terrific benefits that that the use of big data analytics can bring, it can help to let's say, expand access to credit, for example. So let's say that there might be a segment of consumers who may not be deemed creditworthy and therefore may not get access to a credit card. We now, with the use of more data, there might be an alternative way of looking at whether or not, of assessing that consumer's credit risk, and therefore they might have access to credit they may not otherwise have. But at the same time, there's also the risk that it may be harmful. And so what we're advocating is that companies take into account the fact that there may be inaccuracies in their data sets, they may be incomplete, there may be certain inherent biases that may be reflective of disparities that we see in society at large, but that they need to be attuned to those and make sure that just because their data sets are much, much larger, they're not necessarily accurate. And then also, of course, keeping in mind what statisticians know very well, which is that correlation is not equivalent to causation, and therefore they need to be looking at the results and taking a look at those results and ensuring that they're not unintentionally excluding certain segments of the population.
So let's turn now, and one of the recurring themes of both our conversations here, but more broadly about this conference, is the FCC's work on the Open Internet Order, and in particular how it might implicate some of what the FTC does. And in the last year, we've seen a lot of kind of activity and development. I would say the year began with a lot of people, FTC commissioners included, saying, oh, there might be a little bit of competition or turf warfare here between two agencies. A lot of that, I think, was put to rest in November when the director of your Bureau of Consumer Protection got together with the FCC's Enforcement and Consumer and Government Affairs bureaus and came out with an MOU. And it's a short document, but it really does kind of say that two agencies recognize the work done broadly in consumer protection and privacy generally. They're going to work together. I think I've heard it commented, although I don't know if this is accurate, that it was the first formal FCC recognition of the kind of expansive power of the FTC, even over telecom companies, despite the common carrier exception. So anyway, the question is, it also was really open-textured and vague, and so I want to hear more about what you think this future partnership means. Is this a kind of ceasefire, or is this really the end of hostilities, or were there never hostilities to begin with? And what should we expect about the FTC and the FCC walking together in privacy cases in particular, and data security cases going forward? Yeah.
This is a question that I get a lot, and the reality is that we've been working very closely with the FCC for a very long time in the area of telemarketing, enforcing the do not call rule. And we actually have an MOU in the area of telemarketing that dates back several years. Right. So let me just start with that point. But let me just also say that at the FTC, we collaborate with so many different agencies. I mean, just a prime example is the Department of Justice. And I have Bill Baer sitting right there. And we collaborate extensively in the area of, we've shared jurisdiction. And when it comes to competition, we have an incredible this terrific working relationship, and that's the same with a number of other agencies with whom we collaborate. The Consumer Financial Protection Bureau, HHS. Just last week we announced an action involving DeVry University with regard to deceptive claims over deceptive recruiting claims, and the Department of Education is the agency that we were coordinating with there. So this is something that we do, every single day. Right. And I have to say that Tom Wheeler and I, we wanted to make it a point to work even more closely together, given that, of course, they're going to be looking at yet another set of issues where we have shared interests and where we feel that we need to be protecting consumers. And so I think the MOU was an effort on our parts to formalize and institutionalize what is already a very good, close working relationship. I will say that how effectively agencies can work together and coordinate and collaborate really is a reflection of the leadership. Mm-hmm. And I have to give credit to Tom Wheeler, and in the case of DOJ, Bill Baer. When you have that commitment from the leadership, that clearly will translate across all of the work that an agency does. And I really, I fully expect that we're going to be continuing to work closely with Tom. I'm pleased to see that the FCC has become more active in the area of privacy. And I'm look forward to continuing to work and engage with them on those issues.
Right. Yesterday, so this is related. Yesterday, Phil from the stage in the first panel, I forget the number, something like 23 agencies are now in some way purporting to regulate. I know, I'm writing a paper. See, this is the way academics do things. I tell the dean about my next paper article. He talks about it from stage, and then I get to cite him, right? And now this becomes a footnote in the article, so this is perfect. Laying a record is what we call this. But the question is, right? Or bootstrapping, or yeah. So the question is, what is the FTC's either role or responsibility in helping agencies understand some of these issues, particularly ones who've never dealt in this way with software or privacy or data security? I'm not going to purport to know what every other agency has done, but you have the National Highway Transportation Safety Association now talking about connected cars. You have the FDA talking about medical apps. I mean, does the FTC see part of its role being, the kind of, we've been through this, we can help you avoid some mistakes, you should come together with us from time to time to kind of learn some lessons?
Absolutely. We've been thinking about these issues for years at the FTC. It's a core part of the work that we do. And I really feel that increasingly there are a number of different agencies. You cited a couple of good examples. NHTSA is a prime example, right? I mean, they were focused on safety issues, and now when you have connected cars, they have to be thinking about what the impact of
they may not use the word impact,
data.
But yes, yeah.
They're going to have to be focused.
Yeah.
So that's just the reality. So increasingly, we're going to have agencies who previously had not given any thought to these issues, have either confronted with them, and they're going to have to address them in some fashion. So we feel, and this is just another area where we collaborate and coordinate with them. We feel that we have a lot of expertise that we can share, and so we're absolutely engaging. We're engaging with NHTSA. We engage with the FDA, HHS, in the health arena, and I think, to me, the interactions and engagement that we have with the FCC on these issues is just similar to what is happening on multiple fronts. But in my view, the FTC really, because it's really at the core of what we do, I see us continuing to play a very central role in examining, the impact of the use of data and how it impacts consumers. So I think that we're going to continue to be, at the forefront of these issues, and we certainly do intend to share what we know in order to hopefully, make help the broader government effort to address these issues in a sensible way, in an informed way.
That's great. I must confess that when I asked that question, I resisted an analogy to Star Trek, where if your society knows about faster-than-light travel, you're supposed to help the newcomers to faster-than-light travel. So that's the prime directive for the FTC. Okay. Now, we were talking briefly before this, and we said when we got to this next topic, it might make sense for some of the students if I just give a little bit of primer. If you open up a tech blog this morning or a business section of a newspaper, you realize that the internet breaks today, according to some of the reporting. This is because the European Union has said, is it today or tomorrow? Maybe it's tomorrow, that there's a deadline for companies, for the U.S. government to react to the Schrems decision, which, again, leaving out a lot of detail and probably getting some of the detail wrong. This involves the kind of differences in EU data protection law from United States privacy law, such that it is. And one thing that was hammered out at the end of the 20th century was what we call the Safe Harbor Agreement. And under the Safe Harbor Agreement, your company can abide by kind of a menu of obligations that go above and beyond baseline U.S. privacy law. And in return, you get to have customers in the European Union, and you get to take their data and bring it outside the continent, and in particular to the United States. So long story short, in a challenge involving Facebook, the European Court of Justice announced late last year, not that the safe harbor was gone or dead, some of the reporting got that wrong, but at the very least, their earlier pronouncements on the safe harbor were now called into question because, among many other things, of the revelations of Edward Snowden involving the NSA. And so the idea was, because, as we know, the Europeans do no national security surveillance of their own, but specifically the kind of avenues for recourse, the avenues for litigation, the avenues for remedy to European Union citizens in the United States were significantly called into question. For example, when we learned more about 702 and 215, all the NSA surveillance. So, flash forward to today, some European leaders have said, we're going to give you until February to hammer out a new agreement, United States, with us, one that is sensitive to our concerns about the shortcomings of the prior safe harbor. And if you don't, your companies can no longer take data out of the continent. So please correct anything I've said wrong, but the FTC has always played a role in safe harbor enforcement and also has been a symbol to the European Union that some people in the US care about privacy. What can you tell us about where the negotiations are, or what the FTC has been doing in response to all of this?
Sure. And just to round out your explanation, I mean, so the basic frame idea is under European law, a company cannot take data from Europe to another country that is not adequate.
Right. That's not adequate.
And the U.S., Europe has deemed the U.S. privacy laws to be inadequate, and so the safe harbor framework was a way to address that. What the Schrems decision did in October was that it basically invalidated the European Commission's determination that the safe harbor framework provided that adequacy. And what the Schrems decision also said was that the test is whether the protections that are being afforded by the framework are essentially equivalent to the protections afforded in Europe. Now, there had been concerns raised about safe harbor since, frankly, the Snowden revelations. The Federal Trade Commission enforces the safe harbor framework. We were part and parcel of the negotiations that created the safe harbor framework back in 2000 when it was first created, and side by side working with the Commerce Department, we had been involved actually for some time, well over at this point 2 years, in doing what we could to strengthen the framework. I think it's an very important tool that I think provides important protections, but there were areas that needed some examination and strengthening, and we had already been working and in discussions with the European Commission for some time trying to strengthen it. Then comes October 6th when the Court of Justice issues the Schrems decision, and it has not only called into question the safe harbor, but it also raises the possibility that other data transfer mechanisms that are used in addition to the safe harbor framework might also potentially, there might be ramifications of the Schrems decisions that could even go beyond the safe harbor framework.
Right.
So what happened was that the data protection authorities in Europe agreed to forbear, basically, from enforcement and gave the European Commission and the US until the end of January before they would then reevaluate what they needed to do. So that's why that January 31st deadline was in place. We have been working, and the FTC has been, again, part of these negotiations, very hard to address the concerns that have been, conveyed by the European Commission and by others in Europe. And I think that we've taken very significant steps to address those concerns. Some of the key issues do, of course, relate to national security. That's something that's outside of our province, but with regard to the commercial issues, we've been very much at the table since we enforce safe harbor and are absolutely committed to ensuring that framework is complied with by the companies that are part of the program. We have unfortunately reached a point where there is yet no agreement in place at this point. The European Commission is considering a package, the most recent of which was sent to them this weekend, and I'm hopeful that there'll be an agreement. But I think at this point we've reached a juncture where we've put the best proposal forward, and my hope is that we'll be able to eliminate the current uncertainty, because if this goes on much longer, in my mind, it's just an absolutely untenable situation. It is not good for privacy. It's not good for consumers. Certainly not good for businesses to be in this current state of uncertainty, which I think will only be heightened once we get past the next few days, because the European data protection authorities will be determining whether or not they need to start taking action in light of the Schrems decision, number one. And number two, there are potentially broader implications that go beyond the safe harbor framework to these other
Like the model clauses is what you're referring to.
That's exactly what model, binding corporate rules and model clauses. So the impact of there being no agreement is really quite tremendous, and I think, again, we've been working very hard, and I really do hope that we're able to reach a resolution as soon as possible.
I mean, in the meantime, and I know it's not your job to advise companies, I'm sure there are lawyers in this room who have clients worried about what today's deadline mean. I mean,
there's no question. I mean, it's going to create tremendous uncertainty. Let me also just say that this is a discussion, and I'm sure those of you that are attuned to this issue have been seeing a lot of articles about this. It's a challenge because it's the reality is that I believe that we certainly we care very deeply about privacy here in the U.S., but the way that we have protections, the fact that we don't have a comprehensive federal law in this area, it's a very complex system that is not easy to explain. And everything down to our legal system, the fact that we have a common law system, it's very hard to explain to someone who is in Europe and used to a very different legal regime and is used to, and believes very firmly that privacy is a fundamental right. It's very hard to explain the complex way that we go about, in a multifaceted way that we protect privacy. I think we've done a lot at the FTC to explain the role that we play, and frankly, and I think in many respects we do a better job because we've been enforcing in this area, but nonetheless I think there is a bit of a it's a complex issue that is sometimes a disconnect that exists as we try to engage in these conversations.
So there's so many other topics I want to get to, but I want to ask one more quick question about Europe. 2016 will also be, I think, the year we finally see the General Data Protection Regulation, which will replace the former directive. There's so much detail in there that we could talk about. The one that seems to get the headlines is that the penalties are now increased and are pegged to a certain percentage of a company's revenue. So I suppose you could tell us if you'd like that for the FTC, right? Hundreds of millions of dollars of fines. But just generally, if you have any quick reactions on the regulation and what it might mean for the relationship between the FTC and the data protection authorities in Europe.
I think ultimately, we've for the last several years, we've been really engaging very closely. I think our aim is to just only enhance that coordination and cooperation. Right. So I think this, I think it still remains to be seen exactly how all this plays out once it's implemented. I think the one concern I have with the new regulation is my hope is that the changes don't create or impede an ability for us to be cooperating and exchanging information when it comes to enforcement. Right. But at the end of the day, I think we seek the same overarching objectives that the European DPA seek, which is we want to protect privacy, we want to protect consumers, and even though we go about it in a different way, we're all trying to get to the same goal. And I think that we're going to continue to work hard to work closely with our counterparts in Europe, and I think that that's only going to increase going forward.
Great. So let's switch gears again. Your predecessor, John Leibowitz, one of the kind of innovations he brought to the agency, and other agencies had this was a chief technologist position. I believe that recommendation actually appeared in the transition memo on the FTC, and I only have to say that because Phil Weiser wrote that. So. But in my estimation, this is a piece of the FTC's operations that you've really accelerated. That the idea that government agencies should have techies who are not lawyers in kind of every level with a kind of broad mandate and a huge role has really accelerated. So most importantly, the Office of Technology Research and Investigation, which is part of the Bureau of Consumer Protection, has now been stood up. They've been hiring great people. A guy, Justin Brookman, now works there. You've continued the chief technologist role, and Lori Craner has now joined you. So the question is, why is this, is this a priority for you? Why has it been a priority for you? What have the benefits been about having, geeks around? And for other agencies, what are the right ways to do it, and what are some of the lessons that you've learned?
It's been absolutely a top priority, and I do have to give a great deal of credit to John Leibowitz. Ed Felton was our first chief technologist. He was, of course, here yesterday. and he was just absolutely terrific. But it was absolutely clear to me that it was an area where we had to make an even greater investment because so much of what we do, and not just confined to the privacy data security arena, but it impacts other parts of our consumer protection work and our competition work. We need to, given the role the technology plays in today's world, we absolutely need to have people who have the skill set to understand it, both in our enforcement work, so that when we are conducting an investigation and having a conversation with companies and trying to get information from them, that we know the right questions to ask, that folks really, we have people, not only attorneys who also have tech skills, but we have actual technologists who are working side by side with our attorneys. Let me also just say that we have this, when we're dealing with economists who play an integral role with the agency already, right? So we have a Bureau of Economics in addition to our Bureau of Consumer Protection and Bureau of Competition. And to me, that's the model that I would like to aspire to, meaning that, our economists in a competition matter, for instance, I mean, they're part of the team, an integral part of our team looking at a merger. In the same way, when we're looking at many of the issues that we deal with, we need to have technologists really embedded as part of our teams. And so the idea behind the creation of this new office, we call it OTEC for short, is really to consolidate that skill set and to really have a group of technologists who and attorneys who are really have deep technical knowledge, be there and be available to the entire agency ultimately, because so much of what we do requires that. So it's been an absolute priority. Let me say that Ashkan Soltani, our prior chief technologist, really helped me a great deal in attracting talent, because one of the challenges is, how do you, as a government agency, how do you attract that kind of talent? Most people, when they're coming out of school, aren't thinking, they're thinking about, I'd love to go to Silicon Valley, work for all these great companies, or go to a startup. They're not thinking, well, let me go to government necessarily. So one thing that we've done has been to partner with the National Science Foundation, and we're trying to forge relationships to really be able to attract that talent and to show students who are coming out of school that we're doing really exciting, incredibly important work on the enforcement side as well as on the policy side. When we're making recommendations, we need to be sophisticated and we need to understand the complexity of the issues that we're confronting. So that's needed. Let me also just mention that in addition to attracting that talent, and I think it's something that we're now seeing spread to other government agencies, and Ed was talking about that yesterday, but I think it's something that I think we have been a leader in that regard. I've also made it a priority to, and we as an agency made it a priority to really expand the engagement that we have with the technical community. More broadly, we just a few weeks ago had a conference that we call PrivacyCon, which was really building on what we've done before. We often have workshops where we bring together experts to address some of these issues that we've been discussing. But PrivacyCon was unique in that the objective was to get researchers to present original research in connection with various areas relating to privacy and data security. I'd like to even sort of expand further, because my aim is not only to ensure that those of us who are in Washington can ground our recommendations and our policies in really sound empirical research and sound, and really just a greater understanding of all the multiple dimensions of the issues that we're tackling. But I also would like to make it a conversation. In other words, I often, I should be careful with the fact that I'm saying this at a university. When I'm reading an academic article, sometimes I get halfway through and I think, well, this is really interesting, but I'm not quite sure how I would translate with the ideas that are in here into the day-to-day work at the FTC. So I think that by having it be a more intense dialogue, I would like to be able to educate the academic community, researchers who are out there, on what would be helpful to us
great.
so that we can, again, we need to be smarter in the way that we're tackling these complicated problems, and how can we make sure that we really avail ourselves of that talent that's out there.
That's great. That's great. So I still want to give the audience some time, but I have a few questions I want to get to. A big topic, and we've talked about this probably every year we've been up here, is data security. The FTC continues to bring data security cases. In 2015, of course, quite importantly, saw the Third Circuit's opinion in Wyndham. I tweeted that day, and I'm not sure you agreed with this, that this put wind in the sails of the FTC's data security project. And I just want to hear a little bit more about, maybe in a kind of more reflective way, what effect the FTC's data security cases, less on the jurisdictional questions, but what effect this has had on cybersecurity. It was a major topic yesterday at the conference. Maybe one thing you might comment on is the 20-year consent decrees that often will come at the end of one of your data security cases. How important and meaningful, and how well have those been working, right? The fact that there's now auditing and there's report back sometimes to the agency, is that having a meaningful impact, at least for those companies, or maybe more importantly for their peer companies as they go through that consent decree process?
Yeah, so for those of you who may not be familiar with the Wyndham decision, Wyndham, it was an action against Wyndham Hotels that we brought in the data security arena. Wyndham, it was our first litigated data security case, even though we have more than 50 other enforcement actions. But Wyndham challenged the FTC's authority to be in this arena. We firmly believed that we had that authority, and we ended up prevailing with both a very good district court decision as well as a Third Circuit opinion. But I think it's really, to me, we're continuing the great work that we've been doing in this area. But there's no question that data security continues to be a very significant challenge. I see it, frankly, as one of the most significant challenges that our society faces. And I think the conversation and the discussion that took place yesterday about this issue sort of reflects that, the fact that the incentives aren't always aligned. And so what we're trying to do is the role that we play, I think is very important, but it is an issue that requires and needs to be attacked on multiple fronts. We're certainly going to be using our authority and the message that we're trying to convey to companies is they are obligated to have reasonable security measures in place to protect personal information. We take a flexible approach. We do emphasize process, and that's why our orders have focused on having and require companies to have what we call a comprehensive data security program. And really the fundamental aim here is to reinforce the idea that companies need to be, number one, thinking about security. It should be top of mind. They need to be thinking about it early on, not as an afterthought. And we hope that by emphasizing the need for a comprehensive security program, that it helps create a culture of security at a company. And that's really the message that we've been putting out there. So I think the work that we've done has placed important emphasis on these issues, but of course it continues to be a challenge, and the fact that we see headlines about breaches, that's really just commonplace today. It shows that there's a lot more work that we need to do in this. But let me also just mention that in addition to the enforcement work that we do, we understand that especially for small and medium-sized businesses, data security can be incredibly daunting. They may not have the expertise or the resources, and so we're also expanding our efforts to help them and help gather the expertise and provide guidance to them. So one thing that we've done recently has been and we launched this in the fall, is a program to go around the country where we are.
Start with security.
It's an initiative that we call Start with Security, and we launched it out in the Bay Area, where we brought together just experts from Silicon Valley who were able to talk, chief information security officers who were able to talk and to talk about how they tackle these issues and to provide real helpful, practical guidance to companies. So we understand that the companies, and especially again small and medium-sized companies, really see this as something that's a daunting challenge, and we're trying to not only continue with our enforcement work, but to provide more resources so that they can seek to address these challenges.
I mean, one objection you often hear from kind of a small but really noisy part of the commentariat is the FTC needs to have really clear rules on data security, that flexible reasonableness shouldn't be the standard. It should be, here are the 16 things you need to do, and then we'll deem you, to be acting within your legal obligations. What's your reaction to that critique? I mean, it comes in different quarters, right?
Yeah, frankly, I think many companies appreciate that we're not being prescriptive, and I think we do have this reasonableness test, and that's because what a company needs to do by way of security will depend on the kind of information that they are collecting, the size of their operations, on a whole host of factors. So we deem it to be a very fact-specific inquiry. And we don't want to be dictating, especially when things are moving so rapidly, we don't want to be dictating what the precise standards are because we understand that those can evolve. So we believe that taking the flexible approach that we take is really the way, a constructive way of tackling that issue. We think that flexibility is important.
Great. So this one's definitely a little bit out of left field, but I'm really intrigued by it. So in early January, about a month ago, the FTC brought in action against a really despicable operator of a revenge porn website. And in the kind of fallout from that, it made me realize, and so I want you to respond to this reaction, that the role of the FTC in dealing with issues that affect women have not been highlighted as much as some other kind of subgroups of society. I think it shouldn't go without passing that the agency is helmed currently exclusively by women in the top roles. And that is distinctive and really important. So do you agree, A, that the FTC's role hasn't been highlighted? Is this something the FTC should do more of, or at least should be recognized for doing more of? And does it fall within kind of your vision for what the agency should be doing?
I think, first of all, I think it's an important issue, and I know there's been a lot of commentary surrounding issues like this. What I can say is that whatever we can reach with our authority, I think is incredibly important, and I think a lot of the work that we do is, in fact, very helpful to and impacts women in particular. And let me also just say that in terms of the education that we do, we have emphasized things like the impact that geolocation information might have in terms of physical safety, and of course that also has particular impact on women. We also participate, and the administration has a White House council dealing with issues for women, and also girls of color is what the council is called. And so I think we do pay attention to how our work, what kind of an impact that has on women. But I think more attention needs to be placed on these issues just more broadly. This has a number of different components to it, but I do think it's important that we right now have not only all 4 commissioners right now are women, but our top leadership. The director of our Bureau of Consumer Protection is female. Same with our director of consumer of competition, as well as our director of economics. So I think it's important to for us, just as a society, to pay attention to these issues, and we're going to continue to do that at the FTC.
That's great. Last question before I go to the audience. I think it was 2 years ago we talked about the 6B study on patent assertion entities. I know there's a lot of interest in this room, although I'm not an expert in competition policy, but I think there's an overlay between the way the FTC seems to be thinking about patent trolls and competition policy. Can you tell us when the study might be released, or at least what some of the preliminary results are, or what you've learned?
Sure, and as some of you may recall, I've talked about this in past years. This study really was an outgrowth of a workshop that we did actually together with the Department of Justice to looking at patent assertion entities, and our aim really was to go beyond what many studies have looked at when they examine this issue issue of patent assertion activity. Most of the current literature that's out there really focuses on the litigation activity of PAEs, and because we have the authority to compel information from specific companies, we weren't confined to examining publicly available litigation data. So what we are doing is that we are looking very closely at 25 PAEs and their affiliated companies to really examine how it is that they go about their business. What kind of patents are they acquiring? And we're also looking at it from during a 5-year period, so we can get a better handle on sort of the life cycle of their work. So we're looking at what kind of patents do they have, what their assertion activity is, what kind of licensing terms do they enter into, how much money might be coming back to the inventor. So all of these are interesting questions. So we're looking at the hardcore business model. We're also, because we know that there are a number of more traditional non-practicing entities, as well as certain manufacturing companies or operating companies that are engaging in conduct that might be similar to what PAEs are doing. We wanted to also have another dimension to the study, which was a comparative study, to really be able to compare and contrast to see, are they operating in a unique way, or is that line becoming blurred? So I think we're going to be completing our report right now. It will be out this spring, but I think it'll be very interesting because it'll provide sort of a new side of it, perspective that really hasn't been out there before.
Great. So we have a few minutes for a couple of questions. I'm going to invoke the Weiser rule. And so the first question needs to be asked by a student. And I've been on the faculty recently enough that I recognize some students in the room. Oh, I see the 3 students I recognize, all pointing at one another. Callie is someone who's spent a little time at the FTC. What would you like to ask the chairwoman? And the newest Weston Fellow for the IAPP, I should announce, as of a couple of days ago.
Thanks.
So now the pressure's really on. Yeah, no, go ahead.
Now I have to be really well thought out. So one of the projects that I saw happening quite a bit while I was at the FTC last summer were a lot of projects involving public education, and I thought that was a great perspective to take, but I was wondering, how do you guys approach the balance of educating the public enough to be able to protect their own privacy interests versus putting, I guess, too much responsibility on the public so they're overwhelmed by protecting their own interests? Where do you find that balance, and how do you find that without being paternalistic to people?
So I think it's a good question, and I think one thing that we're trying to do is that we need to have consumers who are informed about their rights. When it comes to privacy, I think we still need to have a more sophisticated understanding about how consumers behave, because we see a lot of different studies that we know that consumers, many consumers absolutely, care deeply about privacy, and yet we see them often making choices where they seem to be, not necessarily following through on on their claimed concern about privacy. So look, when it comes to privacy, I think we need to have a more sophisticated understanding of consumer behavior. I think some of the research that we saw at PrivacyCon that I mentioned earlier was quite interesting in that regard, and I think more needs to be done there. But I do also think that that consumers need to be engaged and aware. They need to understand and to the extent that we can bring greater awareness about the implications of the use of data. I think that's really important. So I think both components are crucial. We're going to continue to enforce and make sure that companies stay on the right side of the line when it comes to not violating the law, but at the same time, we need to make sure that consumers are aware of what's happening. And frankly, what I think some good developments that we have seen is that we see companies responding to, I think, a greater consumer demand for privacy protections in the marketplace. So I think that's a good development, and as a competition agency, I think more competition when it comes to privacy would be a very, very good thing.
Any questions from the broader audience? I'm not surprised to see your hand up, Commissioner Zoka. I don't know if you heard, but last night you were named a commissioner of the FCC, or a chairman of the FCC. So, FCC. And it was technically the former FCC because you were charged with unwinding it. So congratulations.
Thank you. Well, Paul, it's bad enough that you got the Prime Directive backwards.
I did? Oh, no. Jeez.
You also really, I think, misstate Wyndham, which in the end actually said that that the FTC had quote, had failed to explain, quote, how it had informed the public that Wyndham needs to look at the complaints and consent decrees for guidance. I mean, I read Wyndham actually as saying that, in a sense, the FTC won that battle but lost the war, because the court really called into question whether the FTC's common law of consent decrees are adequate as a constitutional matter to provide fair notice. And so my question for the chairman is, how do you read the decision? And you now have an opportunity to try to remedy that. What is the agency planning to do to ensure that the next time it goes to court, that it is found to have provided full, fair notice that would satisfy the Constitution? How can you work through your settlements? I know you can't make companies fight you in court, but how can you better explain your analysis under each of the prongs of Section 5 so that when this case comes up again, the FTC doesn't find that its entire house of cards of consent decrees falls apart?
So you won't be surprised to hear that I read Wyndham differently than you do. So I think we absolutely satisfy the constitutional requirements when it comes to notice. I think the tremendous work that we've done over the many years that we've been working in this area, I think we do provide guidance. But at the same time, I think it is important to be flexible and not to be prescriptive. I mean, this is an area that's evolving continuously. And in the engagement that I have with companies, I think many companies say, goodness, I mean, do you really want the FTC to be prescribing what needs to be done when it comes to security? I don't believe that that's the right approach. I think the flexible approach and the reasonableness approach that we take is an absolutely appropriate way to proceed. I think in the law, we see myriad ways in which reasonableness is very much an appropriate test. So I don't think that that's a concept that is in the least bit foreign in our legal system, and I think it's absolutely appropriate the way we're proceeding. At the same time, I do take seriously the concern that companies, and in particular companies that lack the resources of the big companies, that they could use some more guidance and assistance addressing issues when it comes to security, and that's what we've been trying to do with this initiative that I mentioned, Start With Security.
Great. So we're technically 30 seconds over, but I have one very important thing to close on. I would never ask you to talk about a pending investigation, nor would it be appropriate for me to lobby you about one. But 2 years ago, on January 21st, 2014, the FTC announced that it was settling an action with the Denver Broncos for deceptive actions involving safe harbor. 10 days later, they got pasted in Super Bowl 48. So I just want your assurance. You could nod your head or something, but nothing is going to happen to the Broncos in the next few days, right? Could you forbear, or at least delay announcing anything?
Absolutely, for
okay,
you, Paul.
good. We have it right here. So the quote if the reporters are watching is, Chairwoman declares Broncos victors of Super Bowl 50. Please join me in thanking Edith Ramirez.